Welcome back, my dear friends, in my YouTube channel Compliance. In this video, today we are going to discuss about the higher pension judgment passed by the Honorable Supreme Court of India in the case of RC Gupta versus the Employee Provident Fund Organization.
The challenge in this appeal is to an order passed by the division bench of the Himachal Pradesh High Court, reversing the order of the learned single judge by which the learned single judge had directed that the appellant employee would be entitled to the benefit of deposit of 8.33% of their actual salary in the pension fund irrespective of the ceiling limit. Yes. So here the High Court actually reversed the entire judgment which was passed by earlier a single judge bench in the state of Himachal Pradesh, who says that the employee who is actually paying the contribution more than the ceiling amount is actually liable to get the benefit on his actual salary at the rate of 8.33% in the pension fund, no matter whatever the ceiling amount is. Now let's see the facts which lies within the short campus of this Act of 1952. At beginning, it was 10% and later on 12% prescribed contribution for the Employee Provident Fund under Section 6 on basic wage defined under Section 2B. And later on, the provision of subsection 6A was introduced as an employee pension scheme, because the Act of 1952 does not contain any provision pertaining to the pension benefit, and since to provide the benefit of pension post retirement to the provident fund employees, the pension scheme was introduced with effect from 16th November 1955.
Now, soon after 3 months of this amendment, under Clause 11, Subclause 3, a provision was added on 16th March 1996 which expressed a permitting to an employer and employee jointly to make a contribution over and above the ceiling amount of rupees 6,000 or 5,000, whichever, for the benefit of higher pension at the corpus of 8.33% on their pension fund. And with this particular clause, the higher pension come in picture. So, somewhere in 2005, the RC Gupta and other Provident Fund members realized that the amendment of 1996 was not in their knowledge, and therefore they demanded the benefit by the department. They argue that their employer had made the contribution on their actual salary to the Provident Fund, and thus there must be benefit under this scheme of 1996. Now, this plea was navigated by the Provident Fund Authority on the ground that the proviso visualized a cut-off date exercising this option. Number 1, the date of commencement of the scheme, or from the date of salary exceeding the ceiling amount of 5,000 or rupees 6,000, as per the case may be. Now let's see what does the clause number 11 and subclause 3 of the Employee Pension Scheme 1995 says. Clause number 11 speaks about the determination of pensionable salary. Subclause 3 says the maximum pensionable salary shall be limited to the ceiling amount of rupees 5,000, which later on went to rupees 6,500 per month. Now here the another provision got added on 28th Feb 1996 with effect from 16th March 1996, which says, provided that if at the option of the employer and employee, contribution paid on the salary exceeding the ceiling amount of rupees 5,000 or rupees 6,000 per month from the date of the commencement of this scheme, or from the date the salary exceeded from the ceiling amount of rupee 5,000 or rupee 6,000, whichever is later, the corpus of 8.33% share of the employers thereof is remitted into the pension fund, and pensionable salary shall be based on the higher salary. It means the subclause 3, which says that the pensionable salary shall be limited towards the ceiling amount, this particular provision which added on 1996 had given another option to the employer and employee jointly to make the pensionable contribution on higher wage, on actual wage or higher wage, which is more than the ceiling amount, and that is what we call as a higher pension benefit or amount. Now, after reading the provision 11 subclause 3 of the employee pension scheme, the court finds that the reference of the date of commencement of the scheme or the date on which the salary exceeding the ceiling limit are the dates from which the option exercise are to be reckoned with for calculation of pensionable salary. The said dates are not cut-off dates to determine the eligibility of the employer and employee to indicate their option under the provision to the clause number 11 subclause 3 of the pension scheme. Now, somewhat the similar view has also been taken in the matter of the Kerala High Court, where the special leave petition number 707 of the 2014 filed by the Regional Provident Fund Commissioner was rejected by this court by the order dated 31st March 2016. A beneficial scheme in the consideration of the court ought not to be allowed to be defeated by the reference of the cutoff date, particularly in the situation where the employer had deposited 12% of the actual salary and not 12% on the ceiling limit that was 5,000 or 6,000 per month as per the case may be earlier. Now further, there was another argument given by the Employee Provident Fund Commissioner that the appellant employee or RC Gupta had already exercised their option under the provision 26 subclause 6 under Employee Provident Fund scheme. Now let's go through the paragraph number 26 subclause 6 in the Employee Provident Fund scheme. The paragraph number 26 speaks the classes of employees entitled and required to join the Provident Fund. So this particular paragraph is actually going to explain about the different kind of classes of employees which is required to join the fund. But there are so many subclause. We will directly go towards the clause number 6, which is there in the screen. Notwithstanding anything contained in this paragraph, an officer not below the rank of Assistant Provident Fund Commissioner may, on the joint request in writing of an employee of a factory or other establishment to which this scheme applies and his employer, enroll such employee as a member or allow him to contribute more than the ceiling amount of 5,000 or 6,500 of his pay per month if he is already a member of the fund, and thereupon such employee shall be entitled to be benefits to the benefit and shall be subject to the condition of the fund, provided that the employer gives an undertaking in writing that he shall pay the administrative charge payable and shall comply with all the statutory provision in respect of such employee. So here, as we can see, paragraph number 26 subclause 6 give a liberty to an employee to go and pay beyond the to the employer to pay beyond the ceiling amount for the employer for the employee. So on such ground, even the court do not see how the exercise of option under paragraph number 26 of the Provident Fund scheme can be constructed to stop the employee from exercising the similar option which is provided under paragraph number 11 subclause 3. Now, if both the employer and the employee opt for the deposit against the actual salary and not against the ceiling amount, the exercise of the option prescribed under paragraph number 26 of the Provident Fund scheme is purely inevitable. Means there is no thing vice versa effect that if I will practice for paragraph number 11 subclause 3, then I cannot have the option available for paragraph number 26 subclause 6. The exercise of the option of paragraph number 26(6) is necessary precursor to the exercise of the option under the clause number 11(3). Exercise of such options therefore would not foreclose the exercise of the options under paragraph number 3. Thus the Provident Fund Commissioner which argue that since the employee has already taken the benefit under paragraph number 26 subclause 6, therefore they cannot have the benefit under paragraph number 11 subclause 3 of the EPS scheme was actually didn't agreed where the court didn't agree with this statement. The exercise of such option therefore would not foreclose the exercise of further option under clause number 11(3) of the pension scheme unless the circumstance warranting such foreclose are clearly indicated. Since there is no clear indication of any kind of circumstances, therefore an employee who is taking the benefit or a provident fund member who has taken the benefit under paragraph number 26 subclause 6 is equally entitled to take the advantage of paragraph number 11 subclause 3 expressed under employee pension scheme. Thus, in the conclusion of this entire case of RC Gupta versus the EPFO, the Honorable Supreme Court of India stated that apart from the situation where the deposit of the employer, say at 12%, has been on actual salary and not on the ceiling amount, the court do not see how the Provident Fund Commissioner could have been aggrieved to file a leave petition before the division bench of the High Court. All that matter the Provident Fund Commissioner is required to do in the case is an adjustment of account, which in turn would have benefited some of the employee who are the member of the Provident Fund. And at the best, what the Provident Fund Commissioner could do, at which the court permit him to do under the present order, is to seek a return of all such account that the concerned employee may have taken or withdrawn from their Provident Fund account before granting them the benefit under the provision of clause number 11 subclause 3 of the Employee Pension Scheme 1995. And once such return is made, in whichever cases such return is due, the consequential benefit in the terms of this order will be granted to the said employee. So consequently, and in the light of all these entire facts which were present, the court allow the appellant and set aside the order of the division bench of the High Court.